Sorry, my phone dropped.
Your full name?
Are you talking to me?
Yes. Yeah. Could you just state your full name, please?
Okay, well, I think you're rung Caitlin Fiona McDonald.
Thank you. Caroline James Winchester.
Dominic James Grant Clapham.
Courtney Brown. Thank you.
All right, well, good morning, everyone. My name's Mr. Woodhouse. Now, sorry, madam, what was your surname?
Register.
Register. Lovely. And, madam, your surname? Brown. Lovely. All right, well, get yourself settled there, folks. All set to go? All right. Well, good morning to all of you. So, as I said, my name's Mr. Woodhouse. I'm the adjudicator. We've got two matters to be determined. I'm going to begin by clarifying what the issues are that I'm going to adjudicate, because they're actually far more simple than both parties. Okay. Appreciate it. There's only two issues. First, whether or not a rehearing can be ordered in relation to the tribunal's order from the 2nd of May 2023, and secondly, whether rent arrears can be ordered, and that's it. Mr. Clapham, I've read your submission seeking exemplary damages, and they cannot be ordered for these reasons. What you say is that exemplary damages are sought on the basis of the application 4402060. Now, that order does not adjourn the hearing. Well, the order from the 2nd of May does not adjourn the hearing to consider exemplary damages at all. It was a final order. So if you thought that exemplary damages had been missed by the adjudicator, then you either needed to file an appeal or a rehearing. But because no such application was made, the decision's final, and that's it. So the only thing which remains in relation to that particular application is the rehearing request from Ms. McDonald, and we're going to hear that today. So the only other thing, of course, is the rent arrears, and we'll get on to that. That should be a relatively straightforward matter too.
It is,
Any
yeah.
questions before we get going?
Yeah, so I sent Jenny through 5 requests that I asked her to send to you, and they're entirely up to you whether or not you want to grant those requests. But the first one was that I did ask if you could ask the parties to tell the truth. And I think I unfortunately, for personal reasons lately, I was not able to show the proof that the parties have lied, but I don't think it's going to be a very difficult or onerous process for you just to ask the parties to tell the truth, because that gives me recourse under section 111. Now, I'm not asking you to take an oath that was previously mistaken by Robin Merritt. I'm asking you under section, I can't remember what section it is, if you would just ask the parties to please tell the truth.
Yeah, you said there were 5 things. That was the first one. So what's the next thing?
I'm sorry, I don't have it in front of me. My computer's being a bit funny and I didn't print everything off. But look, either Jenny put it on the file or she didn't, but it's with Jenny.
Well, the problem is, McDonald, there's so much communication.
Okay, I can remember another one. No, do you know what? It's really up to, I think, the tribunal. The tribunal has given the registry the discretion to put things on or off the record. Now, the requests I've made are thoroughly well reasoned, and it's quite clearly indicated, and it was quite recent, so I don't think it's going to be much trouble for Jenny to pull those questions up. But they all indicate for me quite good recourse, because as you may or may not know, I do not regard this as a hearing because Section 91 has not been met whatsoever for the matter of what is it? Which is the one that I asked for a rehearing of. It's just been a dog's breakfast. I was never given a notice of hearing at the start, so then therefore no hearings can therefore be based on the first order of tribunal on 25 October, and you can check that for yourself, but that is the truth. So by making the first order of tribunal on 25 October 2022, Mrs. Merritt breached Section 92.
All right. Ms. McDonald, the hearing today is your chance to raise matters that you want to raise. I won't be going through what is 2,000 odd pages of file and addressing all of the points that you've raised. If you want me to address anything, you need to raise it today. I'm going to address these two matters that you've raised. The first is the promise to tell the truth. Now, the tribunal does have an ability to require witnesses to give evidence under promise. Whether or not we're going to hear any witness evidence today, I'm not certain. But the district court has confirmed that the tribunal should not put the parties, so that's you and the landlord, on promise, because the promise only relates to evidence that's given at the proceeding, not submissions. And what the district court said is that if parties are to give submissions, then they cannot give that by way of a promise. They can only give evidence under promise.
I have looked up the definitions, and I'm pretty sure that evidence is broader. I think it just means anything that we say. Yeah.
All right. Well, your request to have evidence put on promise, I've noted that, and if evidence is given, then I'll consider whether to require that to be given on promise. But most of the talking today, I imagine, is going to be done by Mr. Clapham, who's legal counsel and a representative cannot give evidence, so there's no prospect that Mr. Clapham can be put on promise anyway.
Yeah, I know that's fine. I understand it's to the applicant party. He's just acting on their behalf, and I understand that. But nonetheless, they have, he is their mouthpiece. So what he says, they are responsible for because they've instructed him. And I also just want to say, because I know that, I mean, it's up to Jenny what she puts on the file for the adjudicators to access, but these people are not my landlords, and the burden of proof is on the tribunal to show that they are, and that burden has not been met by the applicants themselves, and I have been corresponding myself with my landlord, who is at the moment he has not appointed any intermediary to my tenancy, and he is the sole director of Homewood Real Estate Limited. Now, Caroline says that she owns the PM side of the business. Now, the PM side is one of a couple of subsidiary companies. She owns minor shares in both of them, and is still not a controlling, she's not a director and she's not an authorised person. So she has authorised herself and that's, as far as I'm concerned, not evidence that she is authorised by the landlord. I'm just putting on that on the record, but what I've said to Jenny, and it doesn't matter to me either way if it went on the file, but as I do not really regard this as a hearing, I'm not, I do not regard myself to be the applicant, and I'm just mostly going to observe. But another thing that I did request is that, so Dominic has written an awful lot of points, and he refers us to various appendices. Now, in her order of tribunal, Rebecca Morgan said that the evidence showed that I had unlawfully declined access. Now that hearing wasn't lawful anyway, again under section 91, and so again the order of tribunal violated section 92, but actually she never opened any of Dominic's attachments, and literally none of the attachments showed the evidence that she quoted. She plagiarised, she didn't even direct quote Dominic, she plagiarised Dominic's memo and put it into her order of tribunal. So I just would, if there's another request, and honestly it's of no matter to me, I feel I'm on a strong legal basis here, but when Dominic refers to appendices that he claims prove his points, can he please be asked to quote from the appendices where he believes that the evidence shows what he says.
Okay, now look, I need to address a couple of those points you've raised. So you've submitted that no notice for the original hearing was given that complied with the statutory criteria. I can't decide that, Ms. McDonald, because if you considered that there was a problem in relation to the earlier orders, then the time to take that up was when those orders were given.
Now, I don't mean to interrupt, but I think it's important that I do, because I actually do know the law probably a bit better than most respondents. Not that I regard myself to be a respondent today. If I hadn't been given a notice of hearing, because sometimes they get sent to the wrong address or there's a mistake, then that's fine. It would have been my duty to ask for a rehearing for those reasons. But I asked for a notice of hearing many times and I was refused. So the notice of hearing was simply only to for the applicant to ask for access to my home so they could send a cleaner in to clean my oven. That was in the notice of hearing. What was discussed in the hearing was a whole lot of other stuff, and very, very importantly, that I should be evicted. So that eviction is a very important matter and should have been in a notice of hearing, and it wasn't. So you don't. I am under no. If section 92 was violated, then I have no. There's no legal duty on me to dispute the hearing.
Okay. The original notice of hearing referred to section 56, which is a termination provision in the RTA.
I don't think so. I don't think the original that was on about 12. The thing is that under section 91, the tribunal only ever fulfills subsection B. Under the law, it has to fulfil subsection 1, and it never does. So, and if we were to argue that point and say, well, it's my job to look it up, may I also remind the tribunal that I have been the termination of my tenancy has also been sought on the I think it's section 50A or something, 50A1 or something like that, which is the death of the sole tenant. So I'm not really terribly inclined to take those sections mentioned at all very seriously.
Okay. Well, Ms. McDonald, I'm satisfied that I can hear this hearing. my reasons for that in writing in my decision, and if you disagree with it, then it will be appealable to the district court.
Okay.
Now, the next thing you've said is that this is not a hearing but a conversation, or certainly that's what you've said in communications.
Yeah.
It's a hearing. And we've notified it as a hearing.
Yes, you have, but I haven't received a notice of hearing.
The tribunal doesn't convene conversations for people to have. It's a hearing. Again, if you want to dispute that, it will be appealable. The other point you said is that Harcourts are not the landlord. The landlord is Russell Forward, and he has appointed an agent according to the tenancy agreement, which is Homewood Real Estate Limited. Mr. Clapham, who are you here representing today?
Homewood Real Estate Limited.
All right.
But he's never been
Right.
authorised. He can't
Well-
authorise himself. He's never been authorised. Caroline authorised him, and she authorised him to represent something else.
I'm satisfied that that Mr. Clapham appears today by way of proper authority of the agent. And again, if you want to disagree with that, then it's appealable.
It's not my job to appeal something. It's the tribunal's job to obtain that evidence. One cannot be satisfied of something that is not evidenced. But again, I'm just more interested in what you two parties say to each other, because this is more for my interest than anything else.
Okay. So we're going to now move on, and we're going to hear these two applications. And the first application that we're going to hear is the application for rehearing. We can do it now. Well, I think we'll do this one first.
Okay. We acknowledge your earlier points about the scope of this hearing and the exemplary damages not being able to be sought.
Correct.
There was an earlier decision which dismissed some matters, and one of those matters that was dismissed said that the landlord's application for termination based on rent arrears was dismissed, and other matters were adjourned for a later date.
Yes. And they did mention exemplary damages wrongly, in my view. The original application that the landlord filed in relation to application 4402060 did not apply for exemplary damages. I'm not entirely certain where along the line that's sneaked in, but the application only related to a termination on the basis of the failure to allow entry. Now, irrespective of all of that, Mr. Clapham, the adjudicator issued a decision on the 2nd of May that was a final decision.
Okay.
It carried with it a right of appeal, which you're now out of time to exercise, and there is no ability with an appeal to file it outside time. There is an ability to apply for a rehearing, but you're out of time for that. The tribunal does have some discretion, but in the circumstances, I can't see how the tribunal would exercise that discretion. What I'm saying to you is the ship sailed.
Okay, understood.
Exemplary damages. All right, so we're dealing with the application for rehearing. If the application for rehearing is successful, then what will happen is we will schedule another hearing to consider the matters that were before the adjudicator on the 2nd of May. If the application for rehearing is not successful, then the order for the 2nd of May continues to be in force. The stay gets lifted, so you get a possession order out of it, which is really...
Okay, we'll start with you, Ms. McDonald. Can you please state...
Okay. I think that's all understood and accepted. I think I understand that correspondence between my client and the tribunal confirmed that the application had been amended, and that seemed to have been accepted along the way by the tribunal.
All right.
But otherwise, we expect
if that's the case, it might be the case. It doesn't get over the fact
we accept that.
that the 2nd of May decision is a final decision. Sometimes what a decision will do, like the rent arrears decision, it'll say, I'm deciding this part of the application, but we're going to adjourn this part, and we'll hear that another day. And that's exactly the situation with the rent arrears that we're going to go on and see. So the tribunal has declined to the day, so that's fine. You know, it's a final decision as it relates to the termination. You could have appealed it if you wanted to do so, but there's still the outstanding question of the measuring. That's fine, the tribunal can go on and hear that today. But the 2nd of May order, there was no adjournment of any matters. It was a final order. Now, I have to ask at this stage, has possession of the property been returned to the landlord? Okay. The reason I ask that is if possession had been returned, then really that 2nd of May order would now be moot. But if possession hasn't been returned, then it remains relevant because there's a possession order that attaches to it. Right. Now, the question then becomes, has a substantial wrong or miscarriage of justice occurred, or is it possible that such a situation has occurred? And that's what Ms. McDonald says is the case. So, Ms. McDonald, do you want to tell me what substantial wrong or miscarriage of justice has or may have arisen?
Yeah, again, I've got computer problems. Do you have my application for the rehearing in front of you, by any chance?
Yes, I do. Would you like to work through those one at a time?
Yeah, I think that would be really helpful, thank you. Yeah, look, I've been having computer problems for quite a long time, and Jenny is aware of that, and I have actually asked for some information to be sent to me just because, I had massive problems. I spent $600 getting it repaired recently, but it's still playing up a bit, so that would be really helpful, thank you.
All right, well, that's no problem at all. I don't mind doing that. So what we'll do is I will read out the reason for the rehearing on the application of one.
That's great, and then I might be able to find more detail on my email on my phone.
Yeah, and then so what'll happen? There's 6 reasons here. I'll read it out.
Yeah.
Because Ms. McDonald is the applicant, Ms. McDonald, you then go next and you explain what you want to on that. So you make your submissions. Then I'll go to Mr. Clapham. Mr. Clapham can submit on that point. Then I'll come back to you, Ms. McDonald, and then we'll move on to the next round for the rehearing.
Yeah.
Sound all right?
Yeah.
Okay. All right. Let me just get my notes up to date. Now, the first ground for the rehearing is, and I quote, the tribunal on several occasions failed to comply with Section 91 of the Residential Tenancies Act 1986 for the hearing which was held on 25 October 2022. Accordingly, there was no lawful basis to hear and determine the matter on 25 October 2022 and no lawful basis to adjourn the matter as per Section 92 of the Residential Tenancies Act. As such, it was unjust for the tribunal to rely on this order and making the order on 2nd May 2023 as it did. So, Ms. McDonald, what do you want to say to me in relation to that?
I think you and I had that conversation, and I'm not being facetious. I'm just saying that I was not given a notice of hearing for anything but access to clean my oven.
And that's the original application you're referring to as, for the original
Yeah,
hearing.
the original notice of hearing, and it was very clear from the application that's what they wanted. They wanted an order of tribunal so that the cleaner could come in to clean the oven, and that's a big story. But although it was a false claim, nonetheless that was the claim that I was prepared to hear. Now, on 20, now bear in mind that I think the application is filed on 12 October by Diane Colgan, and they just wanted to get access to clean my oven, which I was denying because cleaning it wasn't a remedy for the disrepair that it was in, and the cleaner herself said, I can't clean rust. But anyway, that was what I was prepared to turn up to the tribunal to easily refute. But bear in mind that the hearing was set for 25 October, so that's 12 to 25 October. That's plenty of time to shoot fish in a barrel. On 20 October, which was I think Thursday or maybe Friday, the day before Labour weekend, Diane Colgan directly emailed Jenny asking to it was put through as additional information, but it was not additional information. It was a separate claim to terminate my tenancy, and no reasons were given. I asked for an amended notice of hearing because I really don't think that 3 working days was long enough for me to prepare to defend that. And I wanted notice of hearing. I wanted to have the reasons given. Diane Colgan would not. She said, we'll discuss it at the tribunal. And I said, that's not fair because I should know ahead of time what we're going to discuss at the tribunal. Now, I was in a state of mental breakdown at that time, and that's a different matter, but that's a different matter that I'll bring to the tribunal and maybe criminal courts later on. I asked for an adjournment, considering that very late edition that was did not meet Section 91 whatsoever, and actually it can't even be claimed that they just wanted to terminate my tenancy because I wouldn't let the cleaner in, because I did not attend that hearing for very good reason, because I knew that I could not cope with 3 bullies who were trying to get me out of my tenancy. And so the order of tribunal actually very clearly showed that matters completely different than the ones that were notified were discussed. So I feel that Section 91 being breached or Section 92 being breached, there was no onus on me to ask for a rehearing, because as I say, I think for a rehearing for a lack of notice of hearing, like that's happened before, like if someone just gets sent a notice of hearing to the wrong place, or if there was an error. But I asked repeatedly for an accurate notice of hearing, repeatedly, and it was repeatedly refused.
All right.
So that's not a matter for a rehearing. That's a matter of, sorry, buddy, but that's Section 92's breached. You cannot. That order of tribunal is void.
Thank you, Ms. McDonald. Mr. Clapham, what does the landlord say?
So in respect of sections 91 and 92 of the Act, Ms. McDonald appears to suggest that the tribunal failed to follow the statutory procedure regarding providing of notice, and therefore the tribunal was not able to issue its decision of the 2nd of May.
No, I'm talking about October. 25 October.
Yes. I think what this really is that the original hearing was flawed, and because of that, all of the subsequent matters equally flawed.
Up to and including the 2nd of May 2023.
Yeah.
So when they not there, not that much more than in respect of the hearing on the 25 October 2022, it's clear from the tribunal's order on that same day that the matter was adjourned for the benefit of Ms. McDonald. For the avoidance of doubt, it is acknowledged that Ms. McDonald was the respondent on that day and in relation to that application.
I just need to say one thing, Dominic. Sorry to interrupt you. Just a point of fact. I didn't claim that I didn't receive a notice of hearing for the 25th October hearing. I claimed that I received a notice of hearing for an order for access to clean my oven. But what was in the order of tribunal was about what was discussed in my absence, which was terminating my tenancy for other reasons. I did get a notice of hearing, and I was prepared to turn up to that hearing and shoot fish in a barrel because it was false. I could have also refuted the rest of the claims that were made and totally secretly from me, but I asked for an adjournment because of three working days notice of a new claim, not additional information, a new claim, and that adjournment was declined. It's entirely unreasonable, but carry on.
So in the Tribunal's order of the 25th of October 2022, the Tribunal did not terminate the tenancy, including but not limited to the reasons given at paragraphs 9 to 10 of that decision, including the following. It appears that Ms McDonald is suffering health difficulties, and this may well be a significant contributing factor in the manner in which she is communicating with the landlord. Taking into account the particular circumstances here, I consider that it would not be equitable, open brackets, fair, close brackets, to terminate the tenancy today.
Can you read the order, the notice of hearing?
Ms McDonald, I'm going to stop you there.
I'm sorry, I apologise.
Please don't interrupt Mr. Clapham. What's going to happen is...
I apologise.
Once Mr. Clapham has made his submissions, I'm going to come to you then and invite you to say anything final that you want to say.
I was in the wrong. I apologise to Mr. Clapham and to you.
No problem, Ms. McDonald. Thanks for that.
Okay, thank you. Insofar as the applicant submits that the Tribunal breached Section 92 of the Act in respect of its ability to adjourn a matter, the respondent submits that Section 96(1) of the Act is equally relevant. This section provides that, quote, the Tribunal may adjourn a hearing at any time and from time to time and place to place upon the application of either party to the proceedings or of its own motion and on such terms as it thinks fit, end quote. It is accordingly submitted that the Tribunal had the jurisdiction to issue all the orders that it handed down in respect of the applications between the parties to this application, and no grounds for rehearing arise. And we've just pulled up the notice of hearing for the 25th October date, and the remedy is, sections quoted in that notice include section 56(1)(a), which is the section that application was made under and defined on. And no further submissions on that point.
Okay, thank you, Mr. Clapham. Ms. McDonald, I'm coming back to you now for any final comments on this point for you.
I think the points I've made as you said at the beginning, and I'm not saying that this is what you had in mind when you said so. This is far simpler than the other party is trying to make it. I just did not get a notice of hearing. I did get a notice of hearing, but I did not get a notice of hearing that gave me any chance to respond to what was actually the contents of the hearing, and that's simply a matter of record. It's a matter of record. It's not opinion. The records are held on file. That's all I've got to say, and I'm happy to move on to the next point.
Okay, let me just catch up with my notes, okay? Now, actually, what I should tell you all, and I should have said this right at the beginning, as we go through, I'm not going to give an indication of how I view all of these matters. When the hearing's finished, I'll be going through the information I've got, and a decision will be issued in writing.
Yeah.
So, just don't expect me to give an answer today.
Oh,
Right.
yeah, totally.
Okay. So the next ground for a rehearing, and I quote, the tribunal and or the adjudicator fails to comply with Section 65 and Section 66 of the Human Rights Act 1993, amounting to an unjustified limitation on the applicant's rights as per Section 19 and Section 27 of the New Zealand Bill of Rights Act 1990. What do you say about that, Ms. McDonald?
Yeah, so I was at the time, I have never managed to find any representation, and I'm a very isolated person, and I've been in Christchurch for a year, and I have been uphill, down dale, trying to find. The thing is that it's not so much that I need help to represent myself. You can see that I'm a, well, I hope I appear to be a clear and confident communicator. That is not the problem. The problem is that I have neurocognitive brain damage. It's an actual brain damage. It's not psychiatric. It is caused from chronic stress, which is usually occurs after 6 months of unrelenting stress, and in my case it's been 19 months. I don't want to get too technical, but it's overuse of the prefrontal cortex, which is used to dealing with novel situations and problems. It's not supposed to be running 24/7, and when you get adrenaline rushing through the blood-brain barrier constantly, you end up producing, I think, more white matter and less grey matter or something like that. Anyway, so my thought processes, although I can speak very confidently on things that are in the front of my mind, my working memory is quite poor. So I've been absolutely unable to put together all of my evidence. And it's what it feels like is I remember as a teenager playing Doom, one of those sort of shoot 'em up games, and you could walk around and the graphics were so bad, and I would often go wandering around trying to look at things more closely, but if I walked up to a wall to have a look at the detail of the wall, it would just become very pixelated. And that is a very good analogy for what it's like for me when I try to focus on preparing the huge amount of information that I have. Now, you do refer to the huge amount of information that I've sent. Now, the reason it's a huge amount of information, that's cause and effect. I have so much evidence against the applicants because that's what I do. I keep evidence, but the matter of organising it in a way that, unlike Dominic, I don't have a unlike the applicants, I don't have a lawyer, and unlike the lawyer, I don't have a paralegal or a law clerk or anything like that. And so ADL, Auckland Disability Law Centre, I approached them, and so my disabilities meet criteria, 3 criteria under Section 21, is it 21A or something of H or something of the Human Rights Act. And my doctor's written a letter to say that I'm cognitively disabled. A psychiatrist wrote that because I have PTSD. The thing is that I just cannot perform on the same level as essentially 6 industry professionals. And I have chronic fatigue syndrome as well. And with chronic fatigue syndrome, mental exertion has the same impact as physical exertion, and they both cross over and affect each other. And so there have been times when I have not even been able to get out of bed. I haven't been able to do my dishes. I'll have a shower with basically a bottle of warm soapy water. I can't do what Dominic can do. And so accommodations were asked for by my ADL advocate, and they were declined. And that was really unreasonable. And to go, I think the next point, and this leads into the next point, is that I did not have counsel. And ADL had asked Mrs. Merritt could we please adjourn all hearings until we manage to find a legal representative for Caitlin. Now, ADL is an office of 3 solicitors, 1 receptionist and 1 manager, so they don't take clients on. Now, Dominic has referred to Toby Cooper as my counsel. He was never my counsel, and he was never actually my representative. Now, what happened was the first advocate, Adelina Lotto Malasea, had written, as I say, to Mrs. Merritt, saying, can we adjourn for about a month to give us a chance to place Caitlin's profile on the Te Ara Ture, pro bono clearinghouse, so she can get adequate assistance to prepare her case, because it's not representation, it's the preparation, right? And get them, that lawyer, up to speed with Caitlin's situation, because you can't just get a lawyer to suddenly come in and represent you. And that's actually what ended up happening, which I'll get to in a minute. And so Adelina made 2 requests, which were, I think, quite clearly intended to be taken together. I don't understand how they could be separated. And then she said that she would like to balance the power difference, which you can see in front. Well, you can virtually see in front of you today the imbalance, right, of the 2 parties. So there was just she asked under, I can't remember what section is, but it would be quoted a bit further down, that she asked, because adjudicators can in some situations grant counsel to representation to one side to even out an imbalance. But what Mrs. Merritt did was she declined the adjournment time, but she granted me counsel. And she said because she granted me counsel, she can therefore grant the other side counsel, like representation, which was irrelevant to the section. It defeated the purpose of redressing the imbalance. And secondly, she misquoted that subsection. It's not, the other party may have representation if the first party has representation. It's not if they've been granted representation. Having been granted representation for a hearing the next day was of absolutely no benefit to me whatsoever for my disabilities. Now, and then what happened, everyone seems to think that Toby Cooper was my lawyer. They were really concerned for me. Toby was busy on his own stuff, and he doesn't know the Residential Tenancies Act. He didn't know my case. Now, Rebecca Morgan stated that Toby represented Caitlin capably. She has no grounds on which she's got no grounds on which to make that claim. She couldn't possibly make that claim. I lost that hearing because Toby didn't know the RTA and he didn't know my case. We had a conversation for 2 hours the day before, and I would have actually been better without representation, because Toby didn't understand my situation, right? So I won't go on about it, but you can kind of see how I would have been better off if Mrs. Merritt had said no to the legal counsel, legal rep, than I would have been before the request, which was also a huge disadvantage to me.
Okay, thanks. Oh, sorry, carry on.
Yeah, no, sorry, I do have a tendency to ramble. I do have ADHD, and I apologise. I take Ritalin, but it's not a cure, it just helps a lot.
Okay. Mr. Clapham, what do you say in reply?
Thank you. So insofar as the hearings for this matter are concerned, the applicant has attended 2 hearings, one in person on the 16th of March 2023 and one by telephone 27 April 2023. The applicant's solicitor was also in attendance by telephone on the 27th of April. At each hearing the applicant has attended, she has been afforded every opportunity to present evidence and submissions in support of her position. Indeed, at the hearing on the 27th of April, the adjudicator allowed a mid-hearing adjournment for the applicant to prepare and make further submissions in support of her case, notwithstanding the fact that the applicant had had time to advance her response to the respondent's claims. It's also not clear what makes the applicant allege she is a whistleblower or other such conflict by sections.
I'm unable to hear. Dominic's cutting out for me.
Okay. I'll move
Do you want to just rewind a bit there, Mr. Clapham?
Yes, certainly. I'll go back to the paragraph before. Indeed, at the hearing on the 27th of April, the adjudicator allowed a mid-hearing adjournment for the applicant to prepare and make further submissions in support of her case, notwithstanding the fact that the applicant had had time to advance her response to the respondent's claim in that matter. It is also not clear on what basis the applicant alleges that she is a whistleblower or other such person contemplated by Section 66 of the Human Rights Act. Additionally, Section 66 of the Human Rights Act requires that a person who is defined as B in the section is or seeks to make use of or comply with the Human Rights Act, not another piece of legislation, for example, the Residential Tenancies Act. Again, it is not clear from the applicant's application for a hearing what rights under the Human Rights Act she seeks or sought to make use of. In any event, it is submitted that the respondent has not treated the applicant any differently because of her alleged attempts to enforce her rights, if any, under the Human Rights Act. And the respondent accordingly submits that no substantial wrong or miscarriage of justice as contemplated by Section 105 of the Residential Tenancies Act applies, and therefore the grounds for a hearing are not made out. And that's all the submissions on that point.
Okay, thanks, Mr. Clapham.
Oh, sorry, there was one further. At one of the hearings, it may have been the 16th of March hearing, Ms. McDonald was in attendance with two support people. My client offered to deal with Ms. McDonald through those intermediaries, and those offers were declined. So all attempts have been made to assist Ms. McDonald in communication and assist her through third parties, but they have all been declined.
Okay, Ms. McDonald, back to you for final submissions on this matter.
Am I able to make a final comment on that?
Yes, of course.
Oh yes, thank you. Just again, I just want to, we're using kind of counsel, solicitor kind of for these purposes pretty much interchangeably. Again, Dominic insists on calling Toby my solicitor. Toby was not my solicitor. Toby is a solicitor. And he made it very clear to Dominic and to the tribunal, and I told Dominic, can you stop contacting Toby, please? He is not my lawyer. He is very busy. Now, Dominic would not take my word for it, and he emailed Toby saying, are you or are you not Caitlin's lawyer? And Toby wrote back very clearly saying, no, I am not. My role is limited to making the initial advocacy and making the submission. And he said, we have no role in Caitlin's case. They simply can't. There's three of them, and that was also clarified to the tribunal as well. And what was the other point? Yes, I was. So I'm not sure what Mr. Clapham is meaning about other legislation, but the RTA explicitly mentions the Human Rights Act and says that it's forbidden to discriminate against anyone on any grounds, and the Human Rights Act prevails anyway. I mean, I don't mean it's going to prevail in every situation, but the point of natural justice, which is the focus of the Tenancy Tribunal, it would be impossible to say natural justice occurs when an experienced litigator goes head to head with a woman with cognitive, like literally neurological damage, and no lawyer. And on the point that he raised about Caroline and Courtney offering to talk to my support people, that is blatantly discriminatory. I have no inability to understand information, and my support people was a friend I'd met in the psychiatric hospital, where initially it was thought that I had a mood disorder, and then it turned out I just had a PTSD, which explains a lot of my what Dominic frames as unpleasant or erratic behaviour, because that's what PTSD does, and it took a while to differentiate a mood disorder from a trauma response, and therefore I was released from the Mental Health Act. And so I had one other poor soul who was there, just couldn't do much for me, and she's got her own stuff. She's got a daughter. She's and the other person was there were two people from MAPS, the Mental Health and Peer Advocacy, and unfortunately they're of no use legally. They were just there for moral support, because I did not want to face the people who had been bullying me into two suicide attempts, which landed me in Hamilton in the first place. So they were just there as buffers for me. They had no ability to understand the law, to communicate the law, and they are stretched molecule level thin. They are a social service that is entirely charitable. They were doing a great favour to me just to be there for me that day, but they can't help me.
Okay, thanks, Ms. McDonald. Moving on to the third ground, and I quote, "The tribunal disregarded relevant considerations and took irrelevant considerations into account, including that in order to terminate the tenancy was made before evidence arising from relevant cross-application claims by the applicant could be considered, and that the tribunal failed to give appropriate weight to the wording of an order of the tribunal made on 16 March 2023.
Yes. Now I'll go to the second bit, the wording of the order. Now, and I'm doing this from memory. I do appear to have changed my mind about participating, so I haven't done any preparation. But as I have said to the other party, it's easier just to keep your story straight when you're just remembering the truth rather than inventing it. So I will just work to my memory to the best of my ability. So what was that the second point you made? I was going to respond to. Oh yes. So
read it out again?
Yeah. No, that's okay. I remember now. Okay. So Mrs. Merritt on the 15th, on the 16th, she had, sent us her order of tribunal, and she was giving me. I mean, it's not fair anyway, because I've never on any occasion disallowed entry to the landlord lawfully. I've disallowed entry to the landlord plenty of times when the entry was unlawful, in which my permission would have had to been given, but never unlawfully. But that's just context. But nonetheless, based on what Mrs. Merritt had believed of the situation, and I have to say, I think based on what she believed, she was being quite kind to me, and she said, you have this final chance to let the landlord give the landlord entry under circumstances he is entitled to, he being his representatives or whatever, and I of course agreed to that. And so the thing is, there are 2 points here. One, lawful entry, and the thing is that if Mrs. Merritt had written in her order, let the landlord in any time he wants under any circumstances, obviously that would be unlawful, because adjudicators cannot order unlawful acts. So it was clearly lawful entry. And the second bit was, the entire purpose of this was to give me a clean slate to redeem myself, as she felt that I needed to redeem myself from the period of the issue of the notice of hearing. And And when the adjourned hearing came about, it was not Mrs. Merritt but Rebecca Morgan who took the case, who took the hearing. And I jotted down a few points, and they're not in front of me right now, but I do remember that firstly, so Dominic started, and she asked Dominic to start, and she asked Dominic to start again as if she knew nothing from the very beginning. And it's like, no, this concerns the 16 March onwards only, because Mrs. Morgan had already made a determination about the preceding time frames, and the very purpose of that was to let me redeem myself. So Ms. Morgan had written in her order of tribunal that she is not persuaded that my new compliance with the with what she felt was the laws that I had breached. She didn't feel that that was a genuine compliance. She felt that it was only because I knew my tenancy was at risk. But that was the entire basis of the adjournment and the chance I was given, do you see? So she was, I'm really not sure. I don't know how adjudicators get adjudicators that come into an existing case. I don't know how they get their information, but she seemed to be very mistaken on what she was supposed to hear and decide on. So she decided on something that wasn't, and what wasn't to be decided. What was the first part of the my objection? If you don't mind, read it to me again.
No, I don't mind at all. The tribunal disregarded relevant considerations and took irrelevant considerations into account, including that in order to terminate the tenancy was made before evidence arising from applications.
And this has been really key for me. Okay, so I think there was a bit of confusion, and it's possible that the confusion is caused partly by myself. But again, it's kind of like that balance of sort of likelihood or probability or what's reasonable. But when I was having great difficulty in putting my cross application together, but I did cross apply. Now these were not separate. I know that cross, and I think this is where maybe my fault comes in, because I have read about cross applications before. I've never made one, in which a cross application can be, well, I also want to raise these other topics, but I didn't do that because I couldn't possibly, and I made it clear to the registry that I will have to make my own claims against the applicant later on when I was capable of doing so. All I wanted to do at that point was to save my home. So my cross application was simply a refutation of the claims made against me. And I believe I made it clear enough that those were the claims. And I did actually spend $203 bringing extra information to the hearing. Now, you do acknowledge, as I freely admit, that the information that I presented there's a huge ton of it, but that is evidence of the fact that I am cognitively disabled, and I've had no one help me put it together, and I've done my best. And the registry does have improved copies of information that I sort of dumped. It's not new evidence, but it's when I've just tried to order it a bit better and put some explanations with it. And I had put quite a bit through before, because I've got every, like, a paralegal could put it together and just show you instantly that the other side's claims are totally baseless and deliberately untrue, because I have the records in their own words, but I just couldn't put it together in a cohesive way. so I did give a bunch of information in my application on the 7th, which was, I tried really hard to do that so in order that it could be heard at the same time, which was the purpose of a cross application, that you can hear them at the same time ideally. So I got it in on time. Now, Mrs. Merritt, for some reason, shuffled everything around, and she sort of changed. So we have two numbers for each of the applicants' claims, and they refer those refer to specific, those application numbers. Application numbers are short. They're short labels for a bigger piece of information. But what Mrs. Merritt had done is change the two into, because one of the claims was for my termination for not letting lawful access and exemplary damages. So there was an action claim and a financial claim under one application number, and on the other one there was again the second claim was for an action order and a monetary order, and that was for rent arrears, and both of them were eviction claims. Now, I was told that by the registry that Mrs. Morgan would, and this was only the day before I believe, has changed her mind, and she's going to hear on the 16th only the landlord's application for termination, and she would hear my claims another time. But they're not my claims, they're directly relevant to, they're my responses, and at the same time I was claiming exemplary damages for false attempt to terminate, which I proved. But she didn't hear my evidence because she characterised them as separate claims. I also got back to the registry, and I know that it's not Jenny's decision herself, she's just passing on what Mrs. Merritt said, but I said I'm really confused what Mrs. Merritt means by the applicant's claim to evict. They've got two claims to terminate. Which one? And then Mrs. Merritt came back with the applicant's claims to terminate. And so what happened was, and then she said the respondent's claims will be heard later. So I was hogtied because she had artificially narrowed the scope, so I couldn't bring in up many of my points. And I had spent, as I said, $203 that I had to borrow from my neighbour, because I'm on supported living payments because I am very, very, very unwell. I can't work, let alone do all this stuff. This is a full-time job. And Mrs. Merritt wouldn't look at any of it. And so her order of tribunal completely failed to take into account the hard proof that I had that the other side was making inaccurate claims. And I won't call them lies because that's for another time, but simply for refuting their claims, the evidence was not looked at, and to this date it has not been looked at. So so for that termination claim, and it's an unlawful claim anyway, for reasons I've given. The applicant has been heard about 4 times, their side, and my side has never been heard. So that's what it means, that Rebecca Morgan failed to take into account the relevant information, because again I'm hogtied. I'm not even saying hamstrung, hogtied. And then she entertained Dominic's introduction of new subjects, which were that I said later to Dominic, I said, look, that needs to be for an antisocial behaviour claim. You know, it's got really nothing to do with the matters at hand. Nonetheless, Mrs. Morgan took his word that I was difficult to deal with and said that given the animosity and that she appeared to believe was caused by me, that was also a ground. But that was not a ground for discussion. Dominic introduced it, and it was just I just really noted that it was and the adjournment that I was granted was 10 minutes basically, and it was just Toby and me going, you know, like she would not let me. She kept me on a very straight and narrow path, whereas she gave Dominic the floor to talk about quite irrelevant topics. And that's all I have to say.
Okay. Mr. Clapham.
Thank you. We may just respond in order of Ms. McDonald's submissions just now. In respect of not allowing access and Ms. McDonald's refusals, the tribunal has already satisfied itself that the refusals to allow access were unlawful and were in breach of the Act, and the timeline set out in the orders, which we won't run through again, supports this to be the case. We're not entirely sure what the submission in respect of Ms. Morgan should have looked at the 16th of March timeline only. But the question was posed to Ms. Morgan to what extent she would like us to set out the background. She asked that we set out from the beginning, and so we did in a very brief manner. And in respect of the hearing and what Ms. McDonald described as being allowed another chance or a clean slate or something to that effect, prior to the eventual access being granted, there had been a further refusal of access, and Ms. Morgan was satisfied that there had been a further refusal of access, and that the subsequent allowal or the granting of access would not outweigh the previous refusals. And Ms. Morgan noted that she was satisfied that there would be ongoing issues with the tenancy if the tribunal was not constantly involved in the matter. So those were her concerns, and her decision followed. Not entirely sure on the cross-application submissions either. However, Ms. McDonald was allowed to make submissions and present any evidence that she wanted to at all of the previous hearings. And as mentioned earlier today, a further mid-hearing adjournment was granted for Ms. McDonald to prepare subsequent submissions at the last hearing. Accordingly, Ms. McDonald has been heard at each of the hearings that she has attended. And in respect of Ms. Morgan allowing new subjects and the issue of Ms. McDonald being difficult to deal with, the submissions that were made on behalf of the landlord in that regard were in response to Ms. McDonald's submissions that the tenants, that the relationship between her and myself had grown to be a positive one, and we made submissions in response to that, raising our concerns, and those concerns were today, and the tribunal's order followed that as well. And so I'll just refer to written submissions now as well. So Ms. McDonald appears to be asserting that in order of termination of the tenancy, the adjudicator made a discretionary decision and that the adjudicator's decision was flawed. We know the Supreme Court case of Consent and Bashir, which confirmed that a general appeal is to be distinguished from an appeal against the decision made in the exercise of discretion. We refer the tribunal to paragraph 32 of that case in particular, but we won't tribunal's decision was not a discretionary decision. Rather, it was a decision issued within the powers acknowledged by the Act. And while the respondent acknowledges the use of may in Section 56 of the Act, this does not make the tribunal's decision discretionary. Rather, having considered the evidence and submissions of the parties, the tribunal issued a decision it was entitled to issue in accordance with the provisions of the Act. And if the respondent is incorrect that the tribunal's decision was not discretionary, which is denied, then the applicant's application does not contain any detail as to what relevant considerations were disregarded and what relevant considerations were taken into account by the adjudicator. In any event, we responded to the applicant's further details today, which doesn't raise any issues as to discretionary decision regardless. However, it is submitted that the adjudicator appropriately and carefully considered the evidence put before her. Accordingly, we have responded to the applicant's further submissions. And there is a further district court decision of low inquiry. And briefly, I'll read this extract out. Quote, rehearings are about challenges to processes and procedures and are not about what the adjudicator found or the decision the adjudicator made, in quote. And it's likely submitted that the grounds for a rehearing have not been made out.
All right, thanks, Mr. Clapham. Anything final from yourself, Ms. McDonald?
Yeah, just repeat a couple of points again that I think Dominic has. I've already sort of pre-refuted Dominic's points, and I just want to briefly make those again. We just need to refer to the order of tribunal made by Robin Merritt. There is no reason for me or the applicant to believe that the order of tribunal was not. I don't think Mr. Clapham can have it both ways, to say an order of tribunal is binding in one case but not in the other. Mrs. Merritt's order of tribunal, which any of us can read right now, very clearly states the reason for the adjournment, which was to give me a final chance to reform my ways, and she has previously acknowledged my poor health and so forth. So whatever the reason that Mrs. Merritt wrote that order of tribunal, which we can all read, nonetheless that was what was supposed to be discussed. Once again, the adjournment that Dominic makes much of that I was allowed, again, was 10 minutes. Okay? And Ms. Morgan did write that the respondent me had stated that her relationship with Mr. Clapham had become positive. That's not how I phrased it, I believe. I won't say anything personal about Dominic today, but I said plenty personal to him, and he knows how I feel about him. And but what I did appreciate is that it looked to me like the landlords were reforming their ways. So rather than sending the owner of the property, the landlord, who told me he was a builder, but and he may well have been a builder, I don't know, but he is not and has never been an LBP, licensed building practitioner, because I've checked the register and I've worked in those areas. So whatever he's been doing has totally failed. So I gave him loads and loads and loads of rope at the beginning. And then I just started to get really fed up with this constant invasion of my quiet enjoyment, because I'd just bloody moved into this house that had many problems with it, and I was going through a hugely stressful time because my movers had fallen through and I had to arrange more movers so I could. It was just a really stressful time, and I was like, look, I am not tolerating this anymore. Every repair that Russell has made has immediately failed or made the problem worse, and I think that's evidenced by the fact that when Dominic came on the scene, I honestly, like, I'm a bit gullible, And I thought that it was a sign of good faith on the landlord part that my requests for, proper experts to attend the repairs, because that's Homewood says the landlord is entitled to do all of his own work. That is totally untrue from a legal perspective, and there is some work that Russell has been doing on the house, not just regular electrical work which you can do only in your own home as an unlicensed, not as an electrician, but he's actually been doing prescribed electrical work which is forbidden except for a licensed electrician. And I was really starting to worry about the safety of this place, and there were many safety concerns. And the fact of the matter is, when Dominic started arranging real repairs people to come in and finally fixing Russell's problems, and I didn't record the people, but I noted and I recorded back to Dominic what had happened during the visit, and I had photos and everything. Like, Russell had put a blind up for me, and the handyman who was an LBP but was just sort of taking a career, taking his career easy, but very experienced. He took the blind apart and he was like, what the hell? There are screws in here that are preventing the pulley from working. There's glue. There's a bracket that's on the outside rather than the inside. So there were points that Dominic had insisted that Russell came in to do work, which he said that I'd refused. There is a quote that was made in Ms. Morgan's order of tribunal from me, and that is my quote: therefore no one is allowed access to my home today or tomorrow or something. Now, that does not, remember that the RTA doesn't say that the tenant can't refuse access. The RTA says the tenant can't refuse lawful access. It was not lawful access. I was trying to find out what it was that Russell was going to do. Now, eventually I said, okay, Russell can come in and do these things. He did not one single one of them. And so that's when I put my foot down and I gave a 10-day notice, and Dominic actually started bringing in proper people and things were done. This included light bulb changes, and the only reason I couldn't change the light bulb myself is that it's one of those ones that requires unscrewing the fixture, and that really requires a ladder, and it becomes a health and safety issue under WorkSafe regulations, where you need a PCBU, and that's not, tenants do not have to carry out any work that endangers themselves. Russell couldn't even do that. So literally nothing was done. So when I refused access, I'm like, again, I don't have time for this bullshit. And it was really just a bit of a setup. But Mark, a lot of work had been done, and I had documented that in detail to Dominic. This was included, and I was really thankful to Dominic. And even though Dominic and I do not like each other one bit, I have the ability, and he appeared to have the ability, to have a functional working relationship in which we could be very civil with each other whilst we arrange these repairs to occur at my home. And so most of those repairs were done, and I was incredibly grateful. So the quote that when Dominic said Ms. Morgan had carefully considered the evidence, I've already refuted that. She literally did not open any of his appendices. She lifted a quote without even showing it to be a quote, so that is plagiarism. Not that plagiarism comes under the RTA as an offence, but Dominic wrote the applicant had said, therefore no one is allowed access. And this is because I wasn't given proper notice, and I didn't know what the hell Russell was supposed to be turning up for. But I eventually did let him come in, and he did nothing. But yes, I did say that. But there is no law that says I have to allow access of any sort. And the fact that the context, the conditional was elided from the quote is very suspicious, because it started with, so not therefore, it started with so. And so why would Dominic quote the second part, which is implicitly follows from the first clause? And so Rebecca Morgan literally just lifted that quote from Dominic's memo and put it into the order of the tribunal, and she actually made a stronger claim than Dominic had made. Dominic said counsel notes, whereas Rebecca said the evidence shows. Now, none of Dominic's appendices contained that quote. I don't think there was any care whatsoever when she made. I think she just decided to not bother looking at any of the evidence, and certainly none of my evidence was taken into account.
Okay.
And that's it.
Rightio.
May I say?
Oh, when you say that.
Like 2 minutes to go to the toilet.
Oh,
I've been sitting here for half an hour even to go. That's all I have to ask.
okay. We'll just we'll pause for 5 minutes.
Okay.
And, Ms. McDonald, are you going to stay on the phone, or do you need to get away from the phone?
I don't know, I might take you to the toilet with me.
Alright.
No, I'm fine, I'm just going to stay here.
Okay, well, if Ms. McDonald's going to stay on the line, you go,
Yep.
and Mr. Clapham and Ms. Brown, you can stay in the room if you like, as long as Ms. McDonald's... Oh, you go, but as long as Ms. McDonald's on the phone. Oh, actually, everyone's heading out, Ms. McDonald. So what I'm going to do is I'm going to head out as well.
Okay.
You can just stay on the line.
Yeah?
You go. I'm going to go out too, and my registrar might need a break. Let's have 15 minutes.
Okay. Would it be a good idea to just have another phone call?
Yeah, that's okay. All right, we'll phone you back at 11:15. Okay.
Okay. Thanks.
So, Mr. Clapham, I'll get you to go out. We'll close the door and we'll bring you back in after we've got Ms. McDonald on the phone. Okay. Great. Okay. Well, thanks everyone. We'll see you in quarter of an hour.
Thanks, Mr. Woodhouse. See ya.
Bye bye. All right, welcome back everyone. Get a cup of coffee or tea. No, didn't quite give you enough time for that. All right, sorry. Now, let's pick up where we left off. We've got Ms. McDonald back on the phone. Ms. McDonald, the next ground in your application for rehearing is, and I quote, the tribunal fails to comply with Section 56 of the Residential Tenancies Act, including but not limited to, by not considering or addressing Section 56(1)(b) as part of its decision. Go ahead, Ms. McDonald.
Okay. I have, while we're on break, I found, and I've sent to Jenny my full reasons for a rehearing, so that might be able to give me a little bit more of a clue about. It was actually Toby who put those reasons together for me, and I've well, you know, he wrote them up in legal language for me, but so I need to interpret that. Oh, no, maybe it's not right. Could you repeat the section again? What section?
No problem. Section 56(1)(b).
Okay. I'm just saying I have hyperlinked some of those in, but I am not sure if I'm going to be able to find it. Can you remind me what section that is? What that is?
Well, okay, Section 56 is a provision which gives the tribunal an ability to terminate the tenancy. And I'm going to help you along here a little bit.
I appreciate that.
So I can understand if Toby wrote this, what he was trying to say.
Yeah,
So-
and just to mention, and I'm sorry for interrupting, but I wanted to add more detail. Like I wanted it to be a comprehensive document that could almost be used to decide a rehearing itself. But Toby said that's not how it's going to work, and we're just going to give the bare bones and then elaborate in person.
Okay,
So-
well, no
yeah.
problem. So Section 56 is a provision which allows the tribunal to terminate the tenancy when the tenant has breached some obligation in the Residential Tenancies Act.
Yeah.
And what subsection 1B states is that if the breach is capable of remedy, that the landlord must provide a 14-day notice that you have complied with.
Ah, yes, thank you. No, I remember. Yeah, no, I can easily reply to that. Yeah, so the other party kept saying the breach is unremediable, and I'm like, I can't. In terms of what they, obviously I'm not fooled by what they call the breaches, but from the tribunal's perspective, what they're claiming to be the breaches, which I had to accept, unfortunately, I was left utterly nonplussed as to what breach had not been remedied. I had complied with everything, and that was the entire purpose. So I'm not sure how Mr. Clapham defines remedy, but every remedy had been made apart from the remedies that the applicant had themselves obstructed, which included cancelling at the last minute a routine inspection.
Okay. Mr. Clapham.
Thank you. So it is submitted that in respect of the hearing on the 27th of April, the parties were provided every opportunity to make submissions on the applicability of Section 56 of the Act. Indeed, the applicant made submissions that Section 56(1)(b applied. The respondent made submissions in response to the effect that the applicant's continued refusals to grant entry to the property was not capable of remedy. The adjudicator issued a decision after considering the submissions and evidence of the parties. These circumstances do not meet the threshold for the tribunal to order a rehearing pursuant to Section 105 of the Act. Even if the adjudicator was wrong in her interpretation of Section 56, which is denied by the respondent, this does not constitute a valid ground for a rehearing, as confirmed by the District Court in Macmillan, which has been cited earlier. Accordingly, the basis for a rehearing is not made out and the application ought to be dismissed. And no further submissions on that point.
Okay. Back to you, Ms. McDonald.
I remember very clearly being, expressing my bewilderment at what was supposed to be there's 2 points of grammar here, and I know that only one point of grammar is really in the wording, but the other point of grammar. So there's is it capable of remedy is the question, and literally all of those things were capable of remedy. They and that they possess the characteristic of remediability or whatever. But I satisfied more than that by having in fact remedied every single one of them. And I'm really unclear about what is so unremediable about an order of tribunal which ordered remedies, which I complied with. And I remember very clearly, because this was really, this is an example of, I felt Rebecca was letting, sorry, I should say Ms. Morgan was letting Dominic just speak on a wide variety of topics that I couldn't have anticipated, and yet she would keep me on this razor edge. And so when Dominic claimed, she asked me to respond to Dominic's claim that these were not remediable, I can't think of anything that hadn't been remediated. And so I said, Dominic, can you please tell me what is left to be remediated? And Rebecca sharply interrupted me and said, that is not Mr. Clapham's role. So I cannot fathom the reason that she made me take the burden of proof for Mr. Clapham's claim, but that's what she did.
Okay. Look, just to let everyone know, after the hearing I'm going to listen to the hearing recording from 27 April, so I'll be able to make up my own mind about what was said or not said or whatever.
Yeah.
Alright, so then the next ground is that the tribunal failed to comply with natural justice to the detriment of the applicant. Ms. McDonald?
Yeah, so that's obviously very broad, and I'm not entirely sure why Toby put that as a separate point, whereas I sort of feel it's an overarching point, but I think the point was, it's not so much separate as just, kind of overarching. And it's just like, if we just zoom back out from the picture a bit and we just take a big look at the whole picture, and I appreciate, Mr. Woodhouse, that you have not been along for the whole horrible ride from September, you can see natural justice is about fairness. It is plain to anyone, and literally everybody that I've spoken to, including people at tenancy services, who have said, there's no way that they can do that. But they, I find tenancy services quite sensible. They seem to be quite clear about what the law is, and I think they have that overview of what is fair and unfair. And I think if you just see that, I know that under section, I don't know what it is, the adjudicator doesn't need to adhere to the strict form of law or something like that. But again, to sort of quote Dominic, that doesn't give carte blanche to making random decisions. And the changes to the strict statutory wording should be made in order as I think the RTA says somewhere, for a fair and expeditious hearing. Now, it's not fair and it's not expeditious, and it's plainly unfair that 3 experienced property managers and 1 litigator who is directed by a firm partner and has a number of staff, and this is his job, and he's not, just on that basis, and the fact that I have not been heard. And Dominic says that I have been given every opportunity to find a lawyer, that I've had every opportunity to say my piece. You can see from the trail of orders of tribunal and memos directly from Jenny, via Jenny's email address from the adjudicator, that so many changes have been made that my head's been spinning. And all of those changes have benefited the other party. So I need preparation time. That's all I can possibly have, is preparation time. And when suddenly new claims are introduced and adjudicators change hearings, hearing contents at the last minute and won't accept evidence that I've submitted and won't let me speak freely on a topic. I mean, I'm not saying all of that has been proven, but you just look at the whole situation and you can just see, like, it's not one or two errors, it's at every step of the way I have been disadvantaged. Every step of the way.
Okay. Mr. Clapham.
Thank you. As you'll appreciate, we hadn't included any substantive submissions in our written format because of the, I guess, vagueness of the application. In terms of the timeline, since the first hearing in October, there have been many adjournments of many of the hearings, and I would hesitate to say all, but I suspect the majority of the adjournment requests were made by Ms. McDonald and granted by the tribunal, despite hearing notices being given well in advance. I think even this hearing was originally set for June, so every opportunity has been given to Ms. McDonald to prepare and present her case, as we've already made submissions on. And just briefly, we've already made submissions, but Ms. McDonald has been heard. She's been given every chance to be heard, give her evidence, make her submissions. The tribunal's made decisions following that, so there's just simply no breach of any kind of natural justice concepts here, and no further submissions, sir.
Okay. Ms. McDonald, anything final?
Mr. Clapham is correct. In fact, I believe that all of the adjournments have been made on my request. Actually, none have been given on my request. They've all been refused. The only requests that have been granted, I believe, have been made by expert advocates such as psychiatrist, barrister, that sort of thing. Psychiatrists and barristers. And I would just like to say, for an example, and I admit that this is a quite dramatic piece of rhetoric, but I think it's quite relevant to note that the first adjournment that was made, because the adjournment of the 25 October hearing, which should have been for me to be heard from the start, not from the point that these guys had already made up their minds. Sorry, Mrs. Merritt, but these guys had already made up her mind that I was in the wrong, having seen none of my evidence. So it wasn't an opportunity for me to actually have my say. It was an opportunity for me to redeem myself. Now, that rehearing was set to be 21 December, and the reason that was adjourned was because I was in Hill Norton Hospital after a suicide attempt, and the purely from my stressful circumstances. As I say, no mental health disorder was found in the end. What was found to be was PTSD and extreme levels of stress from my tenancy situation. And that was made without any judgment on behalf of the psychiatrist. He's not saying that I was in the right. He was just saying that my condition resulted directly from the tenancy problems and the fear of losing my home when I'm very unwell. And I felt that I had no escape because the tenancy tribunal was not behaving in a way that gave me any ability to prepare. So I did try to end my life. I was then taken. I was taken from my home all of a sudden on 7 December under the Mental Health Act, and I was held for a few weeks while I was being assessed. And again, as I say, no mental health disorder was found, not in the sense of the Mental Health Act, and that there was no disordered thinking. It was PTSD. So certainly some bizarre behaviour, but no disordered thinking was found. And so it was just not really plausible to attend a hearing from a psychiatric hospital where you're being sort of recovering and so forth. And so the request for the adjournment was made by a barrister called Trudy Robertson, who worked. She was a barrister appointed by the Duty District Inspector to appeal my. Anyway, like she just did me a favour and said, look, Caitlin can't attend this hearing. So I just want to say that that's not really, granting me an adjournment of a hearing because I'm in psychiatric hospital for suicidality. I don't really feel that that's like being, irrationally magnanimous, and the fact that the adjournments have been granted have shown that it's been recognised when the experts write to the tribunal that Caitlin is not in a state to do this work, which is akin to a full-time legal job, considering my opponent, and I don't have legal training. And I've sort of made the case a few times with the tribunal that this would not drag on as long as it would have if you would just give me proper notices of hearing and make the applicants actually show their case, so I know what it is that because I'm supposed to have evidence to respond to, so I just go in blind and I'm often just left to take the burden of proof. And because the because of the notices of hearing fulfil only 91B, Section 56, whatever it is bloody broad. It's like, how am I supposed to guess what I've done wrong? I haven't done anything wrong, but I've got to somehow guess what it is that I've done wrong. And that's why subsection A needs to be fulfilled. Subsection B is just to give reference to, so the applicant can look up what this falls under. If no one tells me what I've done wrong, how can I bloody prepare for it? Anyway, enough from me.
Okay, so that brings us on to the next claim. Next ground. There's two to go. The tribunal fails to consider claims brought by the applicant with regards to the correct interpretation of landlord and agent as per Section 2, subsection 1 of the Residential Tenancies Act. Ms. McDonald.
Yeah, so at the beginning is that kind of housekeeping stuff. You have already said that you're satisfied that these guys represent my landlord. So if that remains your view, then I won't take it any further.
All right. Look, Ms. McDonald, it does remain my view.
That's fine. Yeah.
Mr. Clayton, I don't need you to provide any further submissions. We addressed that earlier on in the hearing.
Understood, thank you.
So that brings us on to the last ground, and that is, quote, in granting the request by the applicant in applying for representation for the hearing on 27 April 2023, the tribunal's action resulted in non-compliance with Section 93(4) of the Residential Tenancies Act.
Oh yeah, that's about with the discretionary granting of that's right of audience and stuff, isn't it? Is that?
Oh, look, I'll just get it up on my screen.
Yeah.
Section 93(4). Just bear with me.
Yeah, thanks.
I know most sections of the Act, but not an encyclopedic way.
Yeah, no, good for you. Looking it up.
So, Section 94 relates to minors and persons under a disability, and in particular, you're referring to subsection 4, aren't you?
Sir, Section 93, subsection 4.
93, subsection 4. Thanks for that. So 93, is right of audience. Subsection 4 says, where any party to a proceeding before the tribunal is represented by counsel, the other party to those proceedings may be represented by counsel.
Yep, and in my earlier rambles I covered that, but I'll try and cover it again succinctly. The wording, and again I concede and I understand and I endorse even the fact that the RTA allows adjudicators to make wise decisions that may fall outside of the strict statutory wording, but Mrs. Merritt did not do that because, again, I am one person and there are all these people and they are industry experts. Some of them practically live in the tribunal, and Dominic used to practically live in courts defending ACC. This is so I don't think natural justice allows too much leeway for Mrs. Merritt on that point. Now, so I want the statutory wording to be recognised and to draw a very sharp distinction between what Mrs. Merritt said. It said if one party has counsel or is represented by counsel, and Mrs. Merritt interpreted that as if one party is granted counsel. Now, Mrs. Merritt granted me counsel, but I didn't have any bloody counsel. That the entire purpose of Adelina Lotoa-Malasea's first request for the adjournment was so that, one, they could find time for me to get a pro bono lawyer through the clearinghouse. And as I just want to point out, as Te Ara Ture itself makes it very, very, very clear on its website, we are a resource of last resort. Okay, so all these claims that I've had ample time to find a lawyer, I passed the test for Te Ara Ture because I have not. Unfortunately, lawyers are paid not in time but in money, and I don't have money. And most community law centres don't. They want you to present a package. They don't help you do all that stuff. And secondly, they will give you advice, but almost never will they represent you. So that's, I've searched high and low, but so I made the cut for Te Ara Ture, which is no mean feat. So so the entire purpose of the request was to have 4 weeks to find me a lawyer who could represent me, and that clearly indicated the fact that I did not have a lawyer. If the request for me to have time to find a lawyer, it can be almost certainly interpreted to include the fact that I do not have a lawyer, and the way that the Act is worded, it's that if I have a lawyer. And so, and the reason that Adelina had asked for that time, as I've said earlier, was so that she could find a lawyer for me, and part of that request was so and then part and parcel of that request was that I could have a lawyer to represent me in me, not the other side, me, to balance out the enormous power differential. Enormous, like no one can deny the staggering power differential. And so Mrs. Merritt could have easily seen that Caitlin needed an expert on her side, given her condition and given the power imbalance, but she instead just stacked extra power onto the other side, knowing that I didn't have a lawyer and knowing that they had one that was with them almost from the beginning. So Mrs. Merritt granted representation to the other party on a completely irrelevant part of the that section that Adelina had requested.
Okay. Mr. Clapper.
Oh, sorry. I just want to mention that when Mrs. Merritt's reply came back to Adelina, the hearing was the next day. So I was granted I was granted legal representation for the hearing the next day when she knew I didn't have any. And then she granted Dominic leave to represent the other party for the next day. Finished.
Okay.
Yeah.
Mr. Clapham?
Thank you. So the tribunal, in terms of the timeline, sir, had set various applications between the parties down to hearings on separate dates. The applicant, i.e. Ms. McDonald, had submitted an application seeking damages in excess of $6,000, meaning that counsel for the respondent, my client, was entitled to attend at any such hearing. The respondent had submitted a separate application to the tribunal, and damages for which were less than $6,000 at that time. Accordingly, by way of memorandum of counsel for the respondent dated the 24th of March 2023, the respondent sought leave to appear at that upcoming hearing for the respondent's application. Excuse me. The tribunal declined the respondent's request.
You're going a bit tinny there again, Dominic.
Okay.
Yeah.
The applicant also sought leave for counsel to appear on her behalf at the same hearing that the respondent's request, which was denied, related to. Although that request of the applicant was originally declined, the applicant and or counsel acting on her behalf provided further information to the tribunal for why leave to appear was sought. The tribunal subsequently granted leave for counsel to appear on behalf of the applicant. Accordingly, the tribunal, being satisfied that leave should be granted to the applicant, was statutorily required to grant leave to the respondent. In this regard, the section 93.4 is clear and unequivocal, quote, where any party to any proceedings before the tribunal is represented by counsel, any other party to those proceedings may be represented by counsel. In those circumstances, there can be no breach of section 93.4 of the Act, and any argument to the contrary must fail. Even if the respondent and or the tribunal is or was incorrect in its interpretation of section 93.4 of the Act, it is submitted that such an error does not constitute a breach of section 105 of the Act. The respondent again relies on the Macmillan decision in support of its submissions. And I'll just briefly touch on Ms. McDonald's submissions in respect of the power differential. I appeared in matters before the tribunal where various similar arguments have been made, such as there being a Russian doll type approach by an owner being represented by a property manager, being represented by solicitors, and all of those arguments have just been rejected entirely, and we'd submit the same in this case. It's just not a relevant consideration, and it's certainly not a basis that a rehearing should be granted. And there's no further submissions on that point. Thank you.
Okay, thank you for that, Mr. Clapham. Now, Ms. McDonald, is there anything final from you?
Yeah, I'd just like to mention just a couple of things about what Dominic said. He quoted that section of the Act, and he said that that if one party is granted legal representation, again that's misquoting that section. It's if the other party has counsel, not if they are granted counsel. So if we're gonna be really picky, like he wants to be picky, then we've got to be that picky. And secondly, he says that if one party's granted counsel, or let's say has counsel, then the other one has to as well. He says required, but he just quoted a section that says may. So if it were required, it would be must. And the other thing that I wanted to say was by the Tenancy Tribunal refusing to allow ADL find me a pro bono lawyer through Te Ara Ture, it meant that the hearing the next day went through and a decision was made, and I had a conversation with the manager of Te Ara Ture who said, unfortunately, we cannot attract lawyers to cases where at the point that these decisions have been made. They need to be there. At the point where the submissions are made. So I just really need to point out, and I pointed this out to the registry many times, the Tenancy Tribunal, let's say Robin Merritt herself, having insisted black and blue that I had every opportunity to find a lawyer, like I have every opportunity to buy a Tesla because I've had that much time, by letting the hearing proceed the next day and resulting in an order of tribunal which was against my favour, and then a hearing was granted, she actually completely eliminated my chances of even finding a lawyer. And I want to repeat, Te Ara Ture is a resource of last resort, and she cut off my last resort.
Ms. McDonald, can you clarify for me, what's Toby's last name?
Cooper.
Cooper. Okay.
Yeah.
Now, where did you find Mr. Cooper?
He's from Auckland Disability Law, and that's a specialist community law centre. And I did take a long time to approach them because I mistakenly assumed that they serviced only Auckland. But when I was scraping the barrel even further to find some help, I did find actually that they did service the country. However, being a team of 3 solicitors, I repeat again, 3 solicitors and 1 receptionist and 1 manager, they don't have paralegals, they don't even have a clerk. That servicing the entire country, they can only sort of act as kind of hubs, and they can help deal with simple matters of advice. I really would like the record to refute Dominic's insistence of calling Toby my lawyer. He was not my lawyer, he was not my solicitor, he was not my counsel. He works tirelessly. They are basically advocates, and we know that there's a problem with legal advocates who don't have law degrees. So these are legal advocates with law degrees. Think of it that way, they are not counsel.
Okay.
Oh, sorry. How I found Toby was when, because Adelina is a very senior lawyer, and she used to be a public defender. Because of my dire situation, she actually did triage me quite highly, but she had very little time. So when her application to Mrs. Merritt to just take it easy on me and give me a chance to sort of get on even footing with the other side. When that failed, she said, I'm sorry, I'm going to have to pass you on to Toby now. So Toby knew, as I say, Toby had about 8 hours to learn the RTA and understand my situation, and we had a 2-hour Zoom conversation, and that's it. So that's how I found Toby. And Toby stepped in only because he had failed to find any representation for me. He was ringing around everywhere trying to find even just a support person for me, and couldn't. So he just said, look, I'm going to step in, I'm going to do it for you. Bear with me because I don't know, I don't really understand what's going on. Yeah. So, yeah.
Okay. All right. Well, thank you for that, Ms. McDonald. So what we've done is we've heard the application for rehearing, and now we're going to move on and hear the landlord's application for rent arrears.
Yeah.
So obviously I'm going to hear from the landlord first because it's your application. And I've received this morning a copy of the rent ledger. And so this rent ledger goes up until today, in fact. And so if I understand this correctly,
Mr. Woodhouse, sorry for interrupting. It's just you've gone a bit tinny for me as well.
Okay, all right. Well, no, that's all right. I was just
I heard you, but I wouldn't have been able to persist in hearing you.
Okay, I'll pull the microphone a bit closer.
Thank you.
So,
Appreciate it.
go ahead, Mr. Clatton.
Thank you, sir. Just an administrative matter or two before we do move on. Costs are sought in respect of the rehearing application. I'll just refer you to my submissions in that regard.
Okay. Well, actually, I'll deal with it now because it. Well, actually, I presume are you not claiming costs for the rent-to-rent application?
I believe we are.
Yeah. So we'll just deal with the costs at the end.
Okay, all right, understood. Just another administrative point, I don't want to go back and forth on the matter, but we did forward to Madam Registrar correspondence between my client and the Registrar about the scope of this hearing. That was on the 2nd of May, the date of the previous decision. Excuse me. And the correspondence from the tribunal made it clear that the exemplary damages would be heard at the next hearing, and this is the next hearing.
The ship has sailed. I've told you I'm not going to consider it. I'll be putting that in a written decision. If you think I'm wrong, then you appeal it to the district court. That's it. I won't discuss it any further.
Okay, understood.
All right.
Thank you.
Right. Rent arrears. Tell me about that.
So we won't labour through the entirety of the timeline unless you'd like us to, sir. No. Okay.
No, that's okay. Let's just cut to the chase. How much do you say the tenant owes you as of today?
It's $1,819.93.
Okay. Our rent arrears are always pretty straightforward because what I do now is I ask the tenant whether she agrees that she owes that money. So, Ms. McDonald, the landlord says $1,819.93 is what you owe as of today. Do you agree that's the case?
I provisionally disagree, but I just want to be very clear on the terms that I disagree on because I haven't done calculations myself, but I assume these are based on the $70 a week that I did not pay of the total $340 a week rent for quite some months. So if that is the total of the rent arrears from that $70 a week that I didn't pay for that period of time, yes, I will prove shortly that I don't owe those. They're not rent arrears. Yeah, no, I deny it completely. It's ridiculous.
So have you received the rent ledger from the tenant, from the landlord? It was sent through post?
This one, sir.
Okay. Have you had a chance to have a look at the rent ledger, Ms. McDonald?
No, I didn't have a look at the rent ledger. Would you like me to do that now?
Yes, please, because I want to try and go through this and sort it out.
Yeah.
About where the dispute actually arises.
Oh, I'm not making a case, but I'm just giving you a bit of context. I do not dispute that I did not pay that money. I dispute that it's rent arrears.
The amount.
The amount. Sorry, I'll just have a look. I'm not.
Okay, hey, look, let's just pause there. Go and get this rent ledger up, and then we'll have a look at it.
Yeah. I'm just having a look now. Sorry, I'm on my phone where. Okay, so sent through today. Just for the note that in return, because it was sent through today, I've sent through 2 refutations to Jenny that clearly shows that I don't owe the money. But I'll just look at the ledger. Yeah. And no, I remember now. Yes, so there are little bits and pieces. Now those 50-cent payments are to represent zero, but they've made $1.50 out of me just because I had to put in some amount, so I put in 50 cents. They are to represent zero, and that was recorded at the time. I totally agree. As long as the spreadsheet has calculated that amount correctly, then I accept that amount. I did not pay that money, but it is not arrears.
Yeah, so I see the 50-cent payments, and I see what you've done there, but the landlord has treated that as arrears, and because if you see in the right-hand column, they've added the repayments.
No, I know the landlord is treating it as rent arrears, but the fact is that it was compensation.
So you're saying that for those 3 payments, the landlord should have not charged any rent for those 3 weeks?
That is correct. Now, I'll just briefly say that when Diane Colgan, I think in Diane Colgan's original email application, she said that we want this matter about the oven solved promptly because compensation is still running. And because they gave me compensation, which was $70 a week off my weekly rent until my oven was completely repaired. And so I accepted that $70, which I believed was fair. Sometimes I thought it was generous, and then other times when I was really tired and I didn't feel like cooking, I thought actually it's not really enough. And because I would often, order takeaways or something because you can bung something in the oven. So I accepted that, we clearly accepted it, and in Dominic's own submission, you can see that Caroline says $70 a week will run until this matter has been completely resolved. Now, she could argue that she partially resolved it, but I would quite easily show that that's not true. But what happened in the 50-cent period is that Diane Colgan had made an application to the tribunal, as I say, saying that rent arrears was still running, and that's why they wanted the matter dealt with very quickly. Now, she told an untruth. Rent arrears were not still running, and I have an email, and I probably have submitted it to the tribunal, but I can do so again, saying to Diane, because initially they applied for mediation, and I said, no, mediation is for 2 parties who genuinely disagree and who want to work together to find a solution. And I said, I've cancelled the mediation, and I've said that a hearing is more appropriate. Because I don't want to be in a situation where people are pretending to be good cop, and I'd rather it was just an out-and-out dispute. And when Diane had claimed it, but what I had said was, I accept responsibility for having cancelled the mediation, and that means that the matter has been delayed until the hearing. And I said, in good faith, I'm going to return to paying $340 until this gets resolved at the tribunal. So when I've discovered that Diane had written that the arrears was still running, I'm like, fine then, I'm happy to have those arrears. And so they were 3 weeks worth, so I took them back. And I just noted that by way of making a payment, because I didn't want to leave something blank, I just wanted to put a placeholder there. And I think that probably the data from the bank statements will probably, if I know myself well enough, I would have given the reason as well.
All right, let's do this a little bit differently, which might sort of get us there.
Yeah.
I'm going to work out how much rent should have been paid over the entire tenancy. Now, the tenancy started on the 23rd of July. July 2022.
Yeah.
The amount of rent that should have been paid is $340. Does everyone agree with that? Yeah.
What do you mean should have been paid?
Well, the tenancy agreement, how much rent did you need to pay? If no problems arose, it was $3.40 a week, wasn't it?
The agreed weekly rent amount when I signed my tenancy agreement was $3.40, and I never missed a payment.
Yeah, okay,
But-
so
but-
I'll stop there. So it's
yeah.
$3.40.
Yes, but not when compensation was
Hey,
given.
hold on, Ms. McDonald.
Yeah.
And what are we today? Oh, you've calculated it to the 6th of July, which is today, isn't it? Okay, so if the tenancy started on the 23rd of July 2022 and we go through to today, which is what you've done on your rent ledger, landlord, then that is a total of 49 weeks and 6 days. And if the weekly rental was $340, then the tenant should have paid rent totaling $16,951.43. So what we'll do now is we'll go through, and I can see that there were some credits to be paid that were agreed and what have you, and there might be some dispute over that I need to decide. But we'll work out what those credits should have been, and we're going to deduct it from that amount. See where I'm going?
Yeah.
Understood. So I'm going to calculate it myself. I'm going to do it on this bit of paper here. Now, I want to start by saying I can see that there was some agreement to pay some amounts that have sort of slipped my mind. And that was fairly early on in the tenancy. I'm just trying to find it. Here we go. So there was an agreement to pay $490 for the oven and $145 compensation for the washing machine and laundry. Is that right?
Yes, that's correct.
And how was that paid?
Direct debit, I understand.
From our trading account. From our trading account to Caitlin's bank account.
Oh, okay.
So it
this
doesn't
do it as a
reflect in the
rent
ledger.
credit.
Yes, correct.
Just paid the money.
Paid the money across, yeah.
All right. So then we're not going to expect to see that in the rent ledger. So the tenant would be required to pay that money in rent.
That's correct.
Okay. So that brings us on to the $70. And reading the submissions from the landlord, I see there's an agreement that there was a $70 rent credit, but there might be a disagreement over the period of time that applied. So let's start with the landlord. When do you say that $70 rent credit should have started from?
It was 1 week in September, sir, and it's reflected in the ledger.
Okay, don't worry about the ledger. I want you to tell me.
The 8th of September to the 15th.
So the 8th to the 15th of September, that was $70 rent credit, right? Okay. Do you agree with that?
Sorry, apologies, correction. The 15th of September was the date that access was required, so we will say that the credit should apply to the 14th.
All right. So that was 1 week, isn't it?
Talking a week? 1 day difference. So the yes, in total, sir, yes, sorry.
The 14th of September, are we saying $70?
Yes.
All right. And do you say that any other $70 payments should have been credited?
No.
So you say $70, that's it?
Yes.
All right. Ms. McDonald, you've heard the landlord. The landlord says that the only credit that should have applied is $70. What do you say?
I will say it in Caroline Register's own words in an email to me on that same date that Dominic talks about, the 8th of September. So these are Caroline's words. I'm not responsible for them. I'm not interpreting, I'm reading directly. Okay, so let's see. I shouldn't read the whole thing.
Can I just stop you there? Have you got that email in this bundle, Mr. Clapham? This email from the 8th of September from Carolyn?
I believe it is triple F, sir.
Well, let me just find it, so then I can follow it when Ms. McDonald...
There would have been a number of emails exchanged on that day, I know, and just again, I just want to repeat that because I saw that new ledger this morning, I just took that time during the break to send the copy of the email through to Jenny, so it is there, and you can read it yourself very easily from there, but I'm happy to read it.
I'm just going to try and find it. I've got a whole lot of emails here, and so rather than add more paperwork, because the file is big enough.
It is the following, sir. It's G.
But the trouble is that Dominic leaves out the he's very choosy about what he puts on the record.
Right, so Ms. McDonald, you say I should look for an email from the 8th of September.
Yeah, and I sent that through this morning to Jenny.
Okay, we'll just hold on.
It was 9:23 a.m. and it's called Forward 340, paid yesterday, comp stops 27 April.
Okay.
Blah blah.
Found the 8th September email.
There probably will be a few 8 September emails, and the one in particular, if there are more than one, it will be, I'll give you the time, it was 3:30 p.m. from Caroline.
Alright, so here we go. I found an email here from the 8th of September at 3:30 p.m. from Carolyn Register. Hi Caitlin, just coming back to you with an update, and she talks about the oven. With regard to the oven and relevant to my email yesterday, we would like to offer compensation of $70 per week for the loss of service here from the start of your tenancy until this has been fully resolved. And then she talks about the washing machine.
And the washing machine, that's cool. I accepted, whether it's fair or not, that's done and dusted. I accepted her offer and that's fine. I don't dispute that.
And so then you say, then this register says, so currently the $70 per week for oven is still running, of course. I can arrange the $145 for the washing machine to be paid to you, and perhaps the $70 per week up to date, and then we wash up once the total once all finalised. Would that work for you? Just let me know and we can go from there.
And I replied, I accept, thank you very much. My email, the paragraph after that about Courtney's offer of the washing machine compensation, I actually, Courtney was haggling with me over a price difference about what it would cost me to, use the laundromat, which I would go to Riccarton just because it's easier to catch one bus than two. And it's a 10-minute walk, with laundry back, and I thought it was just very poor grace of Courtney to haggle over, 50 cents and $1 about what might cost me to wash and dry my laundry. So I initially said, no, I reject that offer. That's just not in the right spirit. But then I had to think about it, and I thought, do you know what, it's just not worth it. So I actually followed up with Caroline and said, please disregard that, I don't accept that offer too. And there's no dispute about that, and Caroline acknowledged that, and that was all cool. So I just want to say that I did accept both offers.
Okay, so we're talking about the $70 for the oven.
Yeah.
So what you say, Ms. McDonald, is, well, I don't want to put words in your mouth, but I'm just trying to, cut to the chase and sort this out.
Yeah.
So you say that the $70 compensation was to run from the start of the tenancy until it was resolved, because that was what was registered said in that email, and that was what you accepted.
That's right, and those are Miss Register's words, as you can see. I'm not paraphrasing. I'm not making any claims. I'm just reading her words.
Okay.
Sorry, you read her words.
Mr. Clayton, what am I missing here? Because this does read like it's $70 per week from the start of the tenancy, doesn't it? Am I missing something?
Yes, that's correct. So with the tenancy starting on the 23rd of July through to